Cheetos will say, made with real cheese, and if it's not made with real cheese, that lawyer is going to file a class action.
Or Starbucks doesn't extract the foam from its, when it tells you how much is in the cup.
Ah, yeah.
I mean, there was a lawsuit about that.
Did it get dismissed or did it make it?
I hope it got dismissed. I mean, when you buy a cup of coffee, when you buy a latte, there's foam involved, right?
Yeah.
It shouldn't come as a surprise.
There was a big case, and I don't know if you saw it in the news, but it was some kind of a macaroni and cheese. It was either Kraft or something. I don't want to misname which company it was, but there was a company that had like 5-minute mac and cheese. You know what I mean? Fastest mac and cheese. And someone bought it, and it wasn't done in 5 minutes. It took them 6 minutes because they had to open the pack. They had to pour it out. It wasn't 5-minute mac and cheese. They filed a class action lawsuit against this. I think the judge it was like, throw it right out of court.
All right. Somebody else brought a case against Subway because they measured the sandwich.
Well, now listen, if I'm getting the foot long, you want the foot long, right?
Yeah, I know. But if it's 11 inches, really?
Well, that's what I'm saying. So there's a lot of weird, class action lawyers that are out there, but you are like the talented, you handle the big cases.
Well, so since 1992, and it's totally by accident, like a lot of people, like a lot of lawyers, I fell into healthcare litigation. And it started, her name was Liz Tucker, and she had an incredibly advanced Crohn's disease. Uh-huh. This is back when I was in Minnesota. And she had testified before Congress multiple times about Crohn's issues. And as a result, she was an extremely well-educated customer of health insurance. And she went from Cigna or Aetna or something to Blue Cross of Minnesota. Mm. And she noticed that her coinsurance for exactly the same product, which is the supplement that kept her alive every day, was multiple times with Blue Cross that it was in the previous insurer. Nothing else had changed.
Yeah.
It was the same supplement, 1 month apart. And she figured that the coinsurance, which was 20% of the charge, was being calculated incorrectly. And so what she did is she worked her way up through the administrative offices of Blue Cross of Minnesota and documented everything. And what she got is that the 20% was based on the list price, but not the actual reimbursed price. And you couldn't reconcile that with the language in the policy. Yeah. So she walks into our office, and I'm a punk associate, but she walks into the office and she has this entire case all packaged and put together with the admissions and the math and the bills. And at the end of this hour-long conference, she said, "So do I have a case?" And we looked at each other like, "Yeah, what are we supposed to do? You've done everything." And Blue Cross of Minnesota, after we filed suit, did not even answer the complaint. They went right to mediation.
Wow.
And that started about 10 years of my professional life doing nothing but coinsurance cases. And the great thing about those cases, there was no defense. They were all doing the math wrong. They were calculating coinsurance, 20% coinsurance. And this is Blue Cross entities around the country, not just Blue Cross entities, all sorts of health insurance companies around the country. They were calculating coinsurance in a way that you couldn't square with the language in the plan, so that a 20% charge ended up being 50, 60, 70% of the charge because the health insurance company, which had the other half of the bill, had a discount. Mm-hmm. And the discount didn't apply to the coinsurance part, just to the health insurance part. And they were absolutely great cases. we probably had cases in 25 states. And I don't know that we lost a motion. This is my start into commercial class litigation, and I thought, oh, it's all like this. It's all easy. It's not.
It's a lot more complicated.
Yeah, but that was in a really, I'll never have a string like that again, ever. Nobody will.
Never say never. Right?
Okay, fair enough. But they were great cases, and at the end of it, after 10 years of doing it, I know my way around ERISA, which is the federal statute that regulates most health insurance plans. And I have my name tied to a bunch of published decisions. So all of a sudden I'm an expert. People are hitting me up for health care related litigation. And so that, 25 years later, that's still what I do, mostly.
You know what there's so much to talk about today now that you just brought that up, because again, we haven't seen each other for some time, right? I remember me and you worked on a class action case against 411 Pain years ago. All right. 411 Pain, the way they were marketing and advertising, we got together. We had a client that we felt was being taken advantage of, and we filed a class action lawsuit. I know that you took that thing to the end and got it resolved.
What was I was thinking about that case just the other day, because when we started that case, 411 Pain was the only billboard out there.
It was a main billboard.
Yeah, and now
and TV, radio.
But
billboards.
Now they're hidden among all the other. We started that case in part because as a firm, the firm we worked at was sort of offended at the notion of lawyers advertising in that way.
And it wasn't, but what we learned was it wasn't lawyers at the time.
Right,
they weren't lawyers. It was a chiropractic chiropractic office that was almost marketing themselves as if they were lawyers. And 411 Pain call us. We have insurance companies have people defending them. You should have a person defending you. And we realized it wasn't. It was a chiropractic office, and there was kind of a scheme set up there. And I think right at the same time, it may have been Pam Bondi. I know that it was the state attorney general, right after we filed our class action, about 4 or 5 months later, she filed suit and filed a complaint against them as well.
It was a similar case, and I have a feeling it was related.
It was identical.
But I think it somehow sprung out of our case.
Yes. Oh no, absolutely. We were the precipitous, I guess, if that's a word. Yeah. We were the springboard for that lawsuit, which they ultimately had to change their business practices. I know that part of the settlement was they had to change certain things. They had to say certain things in their advertising, their marketing, to be clear. But